Good afternoon, everyone. Welcome to the annual Verrill Dana Labor and Employment Update, at least the first round of it. My name is Robert Brooks. You'll be hearing more from me later. But first, I want to introduce the newest member of our group, Emily Coombs, who has a few introductory remarks to make about this seminar. Emily just joined us last month. And she's a graduate of the University of Connecticut Law School. Before that, she worked for 6 years at Pratt & Whitney in Connecticut in human resources. Before that, she earned her master's degree in industrial and labor relations from Cornell. And before that, she was at Villanova University. So we're really happy to have Emily with us. She has a great skill set and experience and credentials to be a huge asset to our department. So with that said, I'm going to turn it over to Emily.
Thank you, Rob. Good afternoon, everyone. As Rob said, my name is Emily Coombs, and I'm just going to take you through a couple of quick housekeeping items before we dive into the content of today's presentation. So for those of you who are familiar with these sessions, this is Verrill's first ever virtual annual update. So today we're going to be covering a variety of topics, but moving forward, we will be doing hour-long sessions on the third Thursday of each month. And each session will cover a different topic that will be relevant to different areas of your business. So the next session we're going to cover is going to be regarding independent contractors, and that session will be on February 18th. So do keep an eye out for that one. From a logistics standpoint, your audio lines have all been muted to reduce feedback during the presentation. Having said that, we welcome any and all questions, so please do utilize the Q&A feature on your screen, and we'll do our best to answer them throughout the program, and also at the end, if we have time, we'll make an effort to answer all of the questions then as well. And finally, for those of you who are looking for SHRM or CLE credit for today's session, you will find a link in the chat feature of the Zoom, which will bring you to a slide deck as well as the certificates, of attendance for each of those two organizations. So with that, I will turn it over to Calvin.
Thanks, Emily. If we can move to the first slide. Hello, my name is Calvin Wu. I'm a member of Verrill's Labor and Employment and Litigation and Trial Groups and resident here in our Westport, Connecticut office. This slide shows our agenda for our Connecticut update. For those of you who were here during our Maine and Massachusetts updates earlier this morning, you'll probably notice that there is some repetition with some of the topics, particularly as they may be related to the COVID-19 vaccine mandates, the independent contractor rule change, and there's some Supreme Court updates, but we will be sure to point out any Connecticut-specific issues on those areas. We will also be dealing with a few Connecticut-specific updates. We'll get into our state's recently implemented paid FMLA program, as well as a recent interesting decision on the Trade Secrets Act that was before the complex lit docket here in Hartford, as well as the Families First Coronavirus Response Act. Go to the next slide, please. Okay, Rob. Rob, you're on mute, I believe.
Rookie mistake. You'd think I'd have this down by now. This is my third presentation today, so I'm either warmed up or worn out. I'm not sure which it is, but let's see what happens. So thanks so much for being here today. As Calvin said, and Emily said, this is our sort of revamped annual employment seminar. We typically do a day-long seminar and have lots of topics that we discuss throughout the day, and usually cap it off with a nice reception, and it's really a great time. And so we miss seeing you all. This is a poor substitute for in-person meetings, and we look forward to seeing you again when circumstances permit. So this session that we're doing today, again, it's kind of a grab bag of things. But, as Calvin said, we've got independent contractor things, legal updates, so cases from the Supreme Court and from the Connecticut courts, and also legislative updates. And so one thing that we're doing today that's a little different is we're going to be talking a little more in more detail about the COVID vaccines and in particular mandates, just because we're getting questions constantly about the vaccine. Can we mandate them? Can we, what are the risks? Are there going to be workers' comp coverage for this? And we have to pay people for getting the vaccines, for their time to do it. I mean, and so this is something, it's a topic that doesn't typically come up in labor and employment seminars. We haven't dealt with it in detail in past years. And it seems that our clients haven't had to deal with this either. And it's a pretty complicated subject. So we're going to be spending a good chunk of this session talking about that, just because of how timely it is, how much this issue is on people's minds, and how there's some real potential for exposure to employers who don't handle this right. So vaccines, mandates, it's pretty controversial. I think people in this pandemic, and I think everyone's has their own perspective, but it strikes me that the state of the nation right now is just really high in terms of an emotional state. There's a pervasive sense of fear and anger and depression and fatigue. People are on 11, in terms of their sensitivities. So people are either for vaccines or strongly feel that everybody should get a vaccine, nobody should be exempt, and other people are saying you shouldn't make me get a vaccine. I have a right to refuse a medical intervention. People, we're not going to talk about masks today, but that's another issue that's so politically charged. People feel strongly one way or the other, and so it seems like there's very little middle ground these days. And so we're in this charged environment. And so the vaccine issue is one that really presents two conflicting notions. You have public health goals, which are very important on the one hand, and there's a perception that they conflict with individual freedoms to make their own medical decisions. So there's a bedrock of medical ethics is a right to refuse treatment. And I think it's worth looking at a vaccine the way that many do, who have expressed concerns about them, that they're in effect a medical procedure. It's not just a quick, take a pill or a one-off thing. It's a medical procedure that's essentially immunotherapy. And so it's designed to have a lasting, if not permanent, effect on a person's immune system. That's how they work. And so I think the consensus is it's an incredible thing and one of the greatest things ever invented in medical science, and hard to argue with that. But others will say, well, there's risks associated, and I have a right to decide if I want to take a vaccine or not. So you have very strong feelings on that. And so what's interesting here, again, is you've had mixed messaging in terms of whether they're good or bad. And during the recent presidential campaign, you had now Vice President Harris, but then candidate Harris, say that she would not get a vaccine if President Trump recommended it, or if he's, or just because he recommended it. And yet now she's already had it, now that the election's over and she's vice president. So people perceive there's a mixed message there. Not that, but it's not just a political issue. I think that what we're seeing is that it spans political orientation. We're seeing now, just recently reported stories out of California that about 40% of California healthcare workers in certain areas are declining to get the COVID vaccine. And so why would healthcare workers decline it? And why at such numbers, 40%? I don't know, but that's a big number. The Wall Street Journal reported just a couple days ago that a survey in New York State suggested that 26% of the population of New York State is not going to get the vaccine, not just reluctant to or wants to wait, but they're not going to get it. And similarly, there's other surveys that suggest that that's a number that's consistent across the US population. So that's, I think it's just a reality that employers have to deal with, in terms of what are people thinking. And when people are pretty strongly opposed to a particular product, a vaccine and a mandate, you can expect a strong reaction. And so, how else can we look at this? What are some of the other concerns? And I think there are some who sort of brush off the concerns. It's just an anti-vax mentality, but I think that's a little superficial. There are some like that, to be sure. But the media reports, if you read enough of them, you're getting a sense of some stories that are coming out. So for instance, the CDC recorded in the first week of the Pfizer vaccine being rolled out, they recorded more than 5,000 adverse reactions. Granted, that was a pretty broad categorization of the reactions, from just a mild allergic reaction to a hospitalization, but that was 5,000 in 5 days, basically. And so I haven't seen the more recent data, but it suggests that there's some real potential for employees to have some significant reactions. I think the percentage was like 2.5% of people getting the shot had some kind of reaction. News stories coming out again last week. The New York Times reported a doctor, an obstetrician in Miami, who died following the receipt of the Pfizer vaccine. He apparently developed some rare autoimmune disorder that essentially caused his immune system to attack his blood, the platelets in his blood, and wipe them out. And they couldn't revive him, and he had a stroke and passed away. And according to the New York Times article, which quoted a Johns Hopkins expert, it's almost certain that the Pfizer vaccine, led to that doctor's death. And just earlier this week, Monday, the California state epidemiologist issued a statement recommending that like 10% of the state's allotment of the Moderna vaccine not be used because of an instance in San Diego where they had about 10, maybe fewer than 10, healthcare workers all develop severe allergic reactions within the 15-minute period after getting the vaccine. And so they said, we don't want you to, let's not use those for now. Although it's funny, we've been looking at the screens throughout the day because lots of things are happening this week. And just today, the California Department of Health, or their state epidemiologist, said, okay, we can use those vaccines. So now there's sort of a green light to reuse those 330,000 doses of Moderna vaccine in California. But people aren't going to forget about that, very likely. So there seems to be a basis for people to be expressing concerns about side effects. And so then this sort of leads us to, where are we now in terms of the overall environment for what can governments do to make people take a medical product like a vaccine? What can employers do? So for the next slide, please. Thanks. So, what's the landscape right now? So the current landscape is such that in the federal arena, there are no mandates yet. As a matter of tradition and actually constitutional law, the states have reserved for themselves the police powers to look out for the public health and safety. And so the federal government has, for the most part, respected that. And that, of course, I think has been partly to blame for the response to the COVID pandemic. There's been a lot of blame on the federal government not doing enough, but the federal government saying, well, that's how our system is set up. We have a federalist system of government. The states reserve for themselves these powers to deal with public health and safety. This is not like an external threat from a foreign enemy, although it depends on which media reports you read, but I think most people would say this is an internal issue, at least for now, and states are responsible, the 50 states and then the districts. So now we have the states. So what do we have? What are the states doing? And so in general, states have responded differently, as you can imagine. But what can they do? As a general rule, states and local governments actually have a relatively broad discretion to mandate vaccines as part of their police powers to look out for the safety and health of their population. And the foundation for that position is a U.S. Supreme Court case from Massachusetts, or Jacobson versus Massachusetts from 1905. So it's a pretty old case, but it's getting cited a lot in the last year as authority for states to basically to mandate vaccines, to mandate masks, to mandate quarantines, to mandate lockdowns. So Jacobson has been getting a ton of work and in the last year, which is pretty unusual for a case that's that old. And so it does reflect that there's just not a lot of case law out there that addresses the limitations of what a state can do, and then we'll get into what employers can do on top of that. So what are this, and just by way of just the example of what kind of examination is Jacobson getting? Again, it's been held up routinely by legal authorities and other authorities, public health authorities, as saying that, you know, when it comes to pandemics and infectious diseases and vaccines, Jacobson says that the states have the right to mandate that the public get vaccines. So Jacobson was a case about a Swedish immigrant to Cambridge, Massachusetts. There was an outbreak of smallpox. The ordinance was passed pursuant to the state law that said that Cambridge could mandate the smallpox vaccine, and if you didn't get the smallpox vaccine, you had to pay a $5 fine. And so Jacobson said, "I'm not getting it. I had a bad result with the smallpox vaccine when I was back in Sweden," and they took him to court. He lost. Refused to pay his $5 fine. They put him in jail for contempt. But anyway, the case went all the way to the Supreme Court, and the Supreme Court upheld his having to pay the fine. They didn't address the jailing of it, but they said that you know, the city of Cambridge in particular, had the right to mandate that Mr. Jacobson get the smallpox vaccine, and if he didn't, he had to pay a $5 fine. But they also recognized that there was a limit to what the state could do, and if there was a medical issue that prevented them from getting a vaccine, then that had to be recognized. Later cases have also recognized religious opposition to it as well. So about a month ago, the US Supreme Court addressed the New York State mandates to limit the number of people in churches or in synagogues. That was at 10. That was challenged by the diocese in New York and by a synagogue, went up to the Supreme Court, and the Supreme Court, by I think it was a 7-2 opinion, might have been 6-3, but basically the majority found that New York had overreached. Its police power was not so broad as to limit the right of these people to worship. And Justice Gorsuch, in a concurring opinion, focused on Jacobson, and he said, "I don't think Jacobson is as broad as everybody thinks it is in terms of recognizing police powers." And so I think that given the current composition of the US Supreme Court, it would be, you know, I would advise against relying too heavily on Jacobson as giving states and local governments a blank check to mandate vaccines. So what are the states doing? Some states are going the opposite direction. They're saying 9 states are considering legislation that would actually prohibit discrimination because of a person's vaccinated status. And this would go beyond just employment. So it could be customers too. You know, like you can't refuse service to somebody just because they don't have the COVID vaccine. That's still under, of course, these are just bills. These aren't laws yet, but it just goes to show that not everybody is jumping on the "we have to vaccinate everybody" bandwagon. In Minnesota, indeed, the legislation would make it a felony to discriminate on the basis of vaccinated status. So it's really important to stay tuned as to what's happening at your state legislatures and even at the local level. Conversely, New York State's actually considering a bill that would mandate the COVID vaccine for citizens if there's not enough people who have gotten the vaccine to reach herd immunity. And so to the extent, this is where that Wall Street Journal article is so interesting. If 26% of the population in New York refuses to get the vaccine, that means almost by definition, at least according to certain health authorities like Dr. Fauci, you're not going to get to the herd immunity level like Dr. Fauci's talking about. You know, 85, 90% of the population needs to get vaccinated to reach herd immunity to get us through this. So we're just set up for a lot of controversy, a lot of litigation, a lot of continued fighting over this issue. So if we could get the next slide, please. So what's happening in Connecticut? Maybe, thankfully, not much right now. You know, unlike other states, your state legislature, as far as we could tell, as of this week, there's no bill pending to sort of either limit or extend COVID vaccination to any population, and there doesn't appear to be any agency rulemaking. What we've seen in a lot of other states like Massachusetts and Maine and others, the state agencies are getting involved before the legislatures are. So stay tuned, that could happen. You do have in Connecticut a bill pending to remove the religious exemption from school vaccination mandates. I think that was tried last year, got suspended or sort of tabled when the COVID pandemic erupted, but I think that's back before the legislature. But you might keep an eye on how that legislation proceeds as a bellwether for how COVID vaccine legislation might go. Again, I think the same forces that would be opposing the bill to remove religious exemption would be involved in any fight at the legislature over COVID vaccinations. Next slide.
Rob, to your point, that bill that you're talking about doesn't specifically discuss the COVID vaccine, at least not yet, but many are predicting that it may actually be added in some iteration of it. So, even without the COVID vaccine being added on that list, the bill has already met with some strong public resistance from at least some groups. So, to your point, at a minimum, this may be a good example of what to potentially expect from some groups or employees who may not respond well to the idea of taking the COVID vaccine or any proposed mandates for it.
Yeah, or giving it to their kids. I mean, it's certainly possible, and a lot of people are waiting for the COVID vaccine to be mandated for school kids, just to add it to the list, to mumps, measles, rubella, hepatitis B, whatever the list is. It's a long one, so why not just tack it on? The opponents are saying, well, one reason not to do that is because it's never been at least the two vaccines available now have never been tested on kids. So that's I think a reasonable basis for saying it shouldn't be added to the school list, but just wait. I mean, it could happen within the next month, or who knows, next year. So next slide, please. Oh, no, sorry, you're on the next slide. So what about employers? Let's switch from the public arena into the private sector. And again, so I'm not talking about public employers so much as I am private employers. Can they mandate employees receive a COVID vaccine? Why is this question relevant? Well, I mean, everybody's talking about it for one thing. Well, a lot of people, and a survey that came out within the last week of CEOs, and based on the results of this survey, and assuming they're accurate, 70% of CEOs want to mandate COVID vaccines. So it's very likely that the people, all you find people on this call, may be in a position in the not too distant future. If you aren't the CEO yourself, if you deal with a CEO, you may have to deal with a situation or a request as let's make this COVID vaccines mandatory for our employees. And there are lots of good business reasons to do that, especially if you're in healthcare or any business where there's a perception that your employees may pose a threat to other people if they are sick with COVID. So you may be having a conversation sooner rather than later on this. So what's the answer? Can employers mandate vaccines, a COVID vaccine in particular? The answer is yes, maybe. And I know clients hate that kind of answer from lawyers, but the reason why I say maybe is that we just don't know yet. This is a pretty extraordinary circumstance. And so I think it's worth taking a few minutes to sort of understand what employers can do here, in just as a way of introduction here. Most of you are probably have employees at will, right? So you can hire and fire for any reason at any time, as long as it's not any legal reason. And generally speaking, there aren't any laws that say that prevent employers from terminating employees because they don't get vaccinated. So in theory, you should have a green light, and that's why I think the answer is yes. But then and then this yes answer is somewhat supported by what happened about a month ago when the Equal Employment Opportunity Commission issued some guidelines, because clearly this is a question that's been percolating for months and months and months as these, I shouldn't say months and months and months, it's more like months and months, because while these vaccines have been developed and now preliminarily allowed for use. So the EEOC issued guidelines in December that suggests that employers can mandate a COVID-19 vaccine without violating the ADA, the Americans with Disabilities Act, which seems to be the primary law that they're worrying about, and that's certainly within their jurisdiction. So that's why they talk about the ADA. So the ADA basically, just by way of background, prohibits employers from making inquiries about employees' medical conditions and like screening questions, unless they've got some good reason to do it. And so it's business related and job related and consistent with business necessity. And so, and also employers aren't supposed to be doing, a medical procedure or medical exams, I should say, in the context of making these medical inquiries. And the EEOC said, initially, is a vaccination a medical exam, which might otherwise trigger all these ADA protections? And the EEOC said, no, it's not a medical exam. Unless you are doing the exam yourself, in the sense like you give the vaccine, and like any medical procedure, you're supposed to get informed consent. And to get informed consent, you have to ask some questions like, do you have any contraindications? Do you have an allergy? Do you have any reason you can't take this medical product or get this procedure done? And so in doing that, you're sort of opening up Pandora's box, like, okay, now the ADA is triggered. But the EEOC said that a vaccination isn't necessarily is not a medical exam. And if you outsource the operation, basically, when I say outsource, I mean the employer is not doing the vaccination. So you just say, hey, we want proof that you have the vaccine. We don't care where you get it. You don't care, who gives it to you or when, but you need it if you want to keep working here. And so if that's the circumstance, then the EEOC said, okay, well, that's not an inquiry because you're not asking anybody. You're just asking for do they have it or not? You don't care if they've got a medical condition or if there's a religious issue. And so with that sort of limited or narrow foundation, the EEOC said, go ahead. Yeah, that's perfectly legal to fire somebody because they don't get a COVID vaccine. But that foundation, if we could go to the next slide, please. That foundation is somewhat shaky in the sense that it's somewhat unrealistic for an employer to be in a position where they can say, hey, I never asked the person's health status before they got the vaccine because I had them get it done at Walmart or Walgreens or CVS, because when the person comes in and says, they're asked for their proof of vaccination, the employee's going to say, well, I don't have it. And then the employer's going to say, well, why not? Boom, you have to say, why not? Now you're making a health-related inquiry. And so the employee said, or potentially, the employee says, because I got an allergy to peanuts, and I know that in England, they don't, they're not recommending the COVID vaccine to anybody with food allergies. So that's why I've got a medical issue, and so if you've got a medical issue or you've done this inquiry, then you've got another set of rules to comply with from the EEOC, and they say, look, you have to, if you are the one who either administers it or you get this knowledge, you've got to have a job related, the inquiry has to be job related and consistent with business necessity. So this is where, well, what's that mean? Job related and consistent with business necessity. What that means is you got to look at the employee's situation. Are you dealing with a frontline healthcare worker who's dealing with patients and people, members of the public all the time? Or is it somebody who's an accounts receivable who works offsite in some cubicle with nobody around them or near them? And so the answer to whether you can mandate a vaccine and still be compliant with ADA guidelines may differ depending on the circumstances of the job that the employee performs. So how do we know whether something is consistent with the business necessity and job related? Well, the EEOC says, well, you got to look at objective evidence as to whether that employee, if they're not vaccinated, will propose a direct threat to the health or safety of him or herself and others, like coworkers or customers. So how do we know whether somebody is a direct threat? Well, there's some more analysis that we have to do. If you can go to the next slide. So how do we know if someone's a direct threat? Well, they look at, they require this individualized assessment and as to determine whether somebody is presenting, potential harm. And this is in the context of a COVID vaccine, what's potential harm here, especially to others? What we're talking about is transmission, right? How likely is it that someone's going to get someone else sick? And so, well, what's the objective evidence for that? Again, that someone's an unvaccinated person is a direct threat to others. So in this case, the emergency use authorizations that are the foundation for the use of the two current vaccines, Moderna and Pfizer, at least in this country, those are the only two. Those were granted by the FDA based on the manufacturer showing to the satisfaction of the FDA that these vaccines or their respective vaccines reduced moderate to severe COVID-19 symptoms. So basically they made, at least the conclusion from the FDA by the FDA was that these Moderna and Pfizer vaccines make what might otherwise be more severe COVID symptoms less severe. But they've all gone on record, the CDC, the FDA, Dr. Fauci, and the manufacturers, that there's no data yet that either of these vaccines reduce transmission. So that's a pretty important fact. So if you're an employer who's mandating vaccines and you're trying to show by objective evidence that an unvaccinated person is a direct threat to others because they might transmit it, then you call your lawyers and you tell us to go make the argument, and we're going to be scrambling around, and we're not going to find much that these vaccines, at least as of with today's data, will support that conclusion. And so, notwithstanding what I think was a fairly small but some modest celebration by employers that, hey, the EEOC is giving us the thumbs up to mandate vaccines, I'm not sure if this is tested that, at least with today's data, we're going to have an easy time convincing a neutral fact finder that there is any direct threat by an unvaccinated person versus a vaccinated person. Again, and this is consistent with what you're seeing in the media reported from Dr. Fauci and the FDA, the CDC. They're basically saying, even if you get vaccinated, you still have to wear a mask, still have to social distance, still have to wash your hands. And I think employers are still obligated, or at least recommended, to do pre-work screening. Do you have a temperature today? Have you got a cough? So I think that this EEOC guidance provides somewhat of an illusory protection against an employee saying, you can't mandate this vaccine because of my medical condition. And again, it is important to note that these vaccine trials are going on for about 2 years. I mean, and the EUAs are granted after only 2 months. So that's useful to recognize when you're making the decision as to whether you want to mandate these things. Can we go to the next slide? So let's say that, so we talked about employees who may have a medical condition as a reason to say, look, you can't make me get this because of my medical condition under the ADA. I'm protected. And you can't show that I'm a direct threat under that analysis because there's no evidence that a vaccinated person is any less infectious than an unvaccinated person who's otherwise healthy. And again, you start with the premise that everybody's otherwise healthy, they don't have any symptoms. So what do you do with a person who just says, I don't have a medical condition, and there's no particular religious reason why I don't want to get a vaccine. I just don't want to get it. I don't feel like it. So under those circumstances, if that person's an employee at will, you should kind of have a green light. No vaccine and no job. Is there a problem with that? And I think a lot of employment lawyers like me and others that I work with and have talked to have sort of defaulted to the employment at will analysis that, geez, we're everyone's, unless they have an employment contract, then you can terminate anybody for any reason or no reason as long as it's not illegal. And there's generally no rule that says employers can't terminate somebody because they refuse to get a vaccine. So there is this public policy exception to the at-will doctrine, however, and it basically says that employers can't terminate employees if it would violate some public policy or law of the state or the federal government. So as I said a minute ago, these vaccines that have been approved so far, Moderna and Pfizer's, have been approved under this emergency use authorization, EUA, which allows for the use of what they call unapproved medical products in certain emergencies. So it's worth keeping that in mind, that with an EUA applying to these vaccines, they're unapproved medical products, meaning they're not licensed. So the FDA regulations actually say that as a condition of granting EUA on these vaccines, recipients have to be informed they have the option to refuse. So, so you have a federal regulation that basically says people have a right to refuse, whether it's an employee or not. So how does that square with an employer's right to terminate for an employee at will? I don't know. We haven't had that tested just yet. But Connecticut, and this is again a state by state analysis. Not every state recognizes the public policy exception, but Connecticut has. And so it's possible in Connecticut that a court would say that the public policy as embraced by the FDA, that basically people have a right to refuse to take an unapproved medical product, that would supersede the employer's right to terminate at will. So again, in this kind of, when you have a statute or a regulation that's in existence, like a federal regulation, that's a pretty good setup for a court to reach that conclusion. So we'll see. Case law is sparse on this, and we'll see if that case ever gets brought. So can we go to the next slide? So I think we've got some additional issues that'll run through, just because if this wasn't already complicated enough, so it gets even worse. So what about the these other issues with religious exemptions? So let's say I'm a Christian Scientist or some other religion, and I don't believe in any medical interventions. Should that be recognized? Well, the courts, both state and federal, basically say that employers have to accommodate people's religious beliefs. And so you have a similar analysis to like a disability ADA analysis. There's some reasonable accommodation we could find. Can you wear a mask rather than get the vaccine? Can you work from home rather than get the vaccine? All these options that need to be considered by the employer before they reject out of hand the employee's religious beliefs for refusing the vaccine. And so that's a complicated process, and one that takes some time, and again is an individualized process. So what might work for an employee performing one function may not work for an employee performing a different job. It's also important to remember that the EEOC and the courts have been pretty liberal in terms of recognizing what qualifies as a religious basis. So if it's some sincerely held religious, ethical, or moral belief that sort of has sort of elevated status, not just, I think if you just say, well, my body is a temple, I don't put anything in there that, that isn't natural, then I'm not sure that's enough of a fact basis to establish a religious exemption. But I don't think it has to be much more than that. So it's again, this is an area that I think we'll see some activity in the not too distant future in terms of how much of a religious exemption will be recognized by the courts. As an aside, I would say that in the first 9 months of this pandemic, 11 months, the courts have been very, very sympathetic to employers and governments. So in terms of whatever measures they're taking to protect the public interest, employees, and their business interests. So I think that's good. It's a good legal environment for employers to be in, having a very sympathetic government. But as I said a minute ago, the Supreme Court has articulated, several members of the Supreme Court have essentially gone on record, both in writing and in public remarks, speeches, that the Constitution doesn't go on sabbatical during a pandemic. And so I think they've sent us a pretty clear signal that they're taking a much, much harder look at the responses being taken by governments and companies to the pandemic that may infringe on individual liberties. So just stay tuned for that. What's another issue? Unionized employers. Vaccines would be, if you have a union, vaccination would be a mandatory subject to bargaining because it relates to the terms and conditions of employment. So you can't unilaterally implement that unless the contract gives you the right, but it's probably unlikely that you've got a clause in your collective bargaining agreement that says you can implement vaccination. You might if it's a healthcare union, but probably not. Other negative impacts on morale, again, with 26% of the population plus or minus saying they're not going to get the vaccine. If you have, you could have not just people being unhappy and quitting to go work somewhere else. Like if you're a healthcare person, if you lost 5 or 10% of your workforce to go work somewhere else that didn't have a vaccine mandate, that may be difficult if you're looking for people. You're already short on staff. But if you have like two or more people who band together to impose a vaccine mandate, that's arguably conduct that's protected by the National Labor Relations Act. So you can't fire them for engaging in what's called concerted activity. We have similarly OSHA retaliation issues. If somebody says, "Hey, that's not safe. I'm not going to take that vaccine," that employee is arguably protected against retaliation for complaining about workplace safety issues under OSHA. And now you've got workers' comp claims for vaccine injuries. Good news, I guess, is that very likely if somebody experienced an injury, it had an adverse reaction to a COVID vaccine that was mandated, that it would be covered by your workers' comp carrier as a work-related injury. Of course, that might explain why many workers' comp carriers are telling their insureds, don't mandate the COVID vaccine, make it voluntary, because if it's voluntary, then it's much less likely to be a work-related injury. Again, the employee chose to take on that risk. It wasn't a risk associated with employment. So lots of issues having to do with the COVID vaccine. I chewed up a lot of our time on this, but if you have questions, by all means, type away in the question box, and I'm going to turn it over to Calvin now as we switch topics to independent contractors. So take it away, Calvin.
Okay, yeah, if you can go to the next slide, please. Okay. In September of last year, the Department of Labor, through the old administration as of yesterday, issued a new proposed regulation that set forth the standard for determining a worker status as an independent contractor under the FLSA. The proposed rule is on the left column of this slide. It identifies 2 core factors out of 5 that it considers to be the most probative and to afford the greatest weight for the analysis. They are the nature and degree of the worker's control over their work and the worker's opportunity for profit or loss based on initiative or investment. And this is known as the economic reality test. Now, even though this was put forth last year by the Trump administration, if you subscribe to our blog posts or any of our alerts, you probably did not get an alert from this or from anyone else. And that is because we, as well as many others, are under belief that the Biden administration has come in as expected that the test on the right column is going to be the test that will be applied, which is known as the ABC test. That is a broader test than the proposed economic reality test, would likely lead to more employee classifications when compared to what was proposed by the Trump administration. And you folks here in Connecticut should be familiar with this test because it's the same test that the Connecticut Department of Labor currently uses. The factors for that test are in that second column of the slide, where the company must show that the worker, 1, has freedom from control over how to perform their services, 2, that the services are outside the business's normal variety of work, and 3, that the worker is engaged in an independently established role. So this is definitely a rule in flux and something for us all to keep an eye on. Next slide, please. Okay, this slide identifies some key Supreme Court activity that we in the employment world should be mindful of in the new year. First, the Bostic versus Clayton County case. That is a decision that was issued by the High Court in June of last year. In this landmark decision, the court had ruled that Title VII protects gay and transgender workers from workplace discrimination. This issue came about before the court because Mr. Bostic's employer, which was Clayton County, had fired him because he decided to play in a gay softball league. In finding that Title VII applies to sexual orientation and gender identity, the court has now provided support for LGBTQ individuals in states that did not previously include them as a protected class, or had offered some, but much less extensive protections. The Henry Schein matter, that is a case that employers should keep an eye on as potentially being relevant as it relates to arbitration agreements. There are multiple reasons why an employer would want to have a dispute resolved by arbitration as opposed to the traditional path of state court or federal court, including, among other things, the confidentiality of proceedings that you get at an arbitration, which would otherwise be open to the public, as well as any filings you do in a court. Of course, unless you have a protective order, but that is very difficult to get in the state of Connecticut. The looseness of the rules of procedure and discovery, which could make things less expensive as an employer if you're defending a case, and less time consuming if you wish to have a matter resolved more quickly. And finally, the idea of predictability as to who you choose as an arbitrator. In the court system itself, you obviously get a judge who is, for the most part, left to chance. Although you do have a little control if you opt for the complex litigation docket in Connecticut, you do have only 3 venues from which to choose and only a few judges. So the selection there is a little bit less. So in that Henry Schein case, it's a technical issue that's being examined there, but the court's ruling should shed some light on how to draft arbitration agreements to ensure their enforceability, as well as what matters could potentially be arbitrated. And along those same lines, the High Court may also get into the issue of the scope of the Federal Arbitration Association, the Federal Arbitration Act exception to certain transportation workers. The FAA provides a narrow carve out to interstate transportation workers, and the application of this exception for arbitration has had some potentially conflicting decisions in a couple of lower courts in the past year, particularly as related to last mile delivery drivers. And those are the drivers who get the goods to their final destination. Last year, the First Circuit held that this exemption did in fact apply to last mile drivers who happen to be, in this case, the Amazon drivers that you get to drop packages off at your house, which probably many of you are getting right now during this time. Even if they themselves didn't cross the state lines, because they were found to be an integral part of the interstate flow of the goods. They were known as the last mile of the interstate commerce journey for those goods. But shortly after the decision was issued, actually only a few weeks later, the Seventh Circuit actually rejected a claim brought by Grubhub workers who claimed that they fell under, who also tried to claim that they fell under an exemption. And it was rejected. And that was despite their argument that they also were delivering goods that had some point moved across state lines. So what these cases show, or where they will show as they relate, is that there is definitely continuing litigation at the Supreme Court level on arbitration agreements. Both their scope as well as their enforceability and the way that they're written are very much being looked at by the High Court. This is something that we all have to be mindful of as we consider and we advocate or potentially advocate for the use of arbitration in as a venue to hear our employment cases.
I guess further to Calvin's point, I think that the surveys that have been done of the Fortune 500 companies suggest that about 60 or 70% of them use mandatory arbitration with their employees. And so I guess if you may want to ask yourself, if I'm not using mandatory arbitration to resolve disputes with my employees, why not? And there may be lots of good reasons, as Calvin articulated. There's some drawbacks to arbitration, but there are also some benefits. But the Supreme Court decisions over the last decade or so have been pretty consistent in recognizing the enforceability of arbitration clauses in employment. And but obviously, draft, as the Henry Schein case points out, and Calvin mentioned, how you write the agreement is really important. And if you have an arbitration agreement that's old, or you find out on the internet, it may not be what you want. And so these agreements are highly can be customized to your business, and the Schein case will hopefully give us a little more guidance on how much we can customize them to be and still be lawful.
Thanks, Rob. And finally, the Van Buren case. That is a case that is technically a non-employment type of case, but it may have some significant impact on employers, particularly those who deal with the protection of trade secrets as they relate to their current or former employees, or any matters involving NDAs or non-disclosure agreements. The case Van Buren actually involved a former police officer who was convicted of violating the CFAA by looking up information on a police database at the request of someone who was not involved in law enforcement, but for whom the officer was supposedly doing a favor. The officer is appealing the conviction, stating that the law only applies to individuals who had access to the computers without any authorization, which obviously he is contending that he did as a police officer. Now, what makes this case significant is, or something to watch out for, is to see how the Supreme Court handles the scope of the statute. The case could be particularly significant for any companies who want to avail themselves of the CFAA, as well as the Connecticut state statute, which essentially mirrors the federal statute, in order to potentially enforce claims against workers who may have accessed or distributed confidential information. Next slide, please. The Connecticut paid FMLA just took effect in the new year. And although the benefits don't start until January 2022, employer obligations under this act took effect at the start of the year by requiring employee deductions to pay for this program. This program is significant, not only because it's new, which obviously in of itself makes it significant, but because of who it applies to and who it covers. The program applies to all employees with at least one employee in the state. Self-employed individuals are allowed to participate as well. There is also now a brand new quasi-state agency known as the Connecticut Paid Leave Authority that was created in order to administer this program. And employees under this would then be permitted to take paid leave under this program, as the slide says, as early as January 1st in 2022. And they would be able to under the same reasons that are covered in the existing FMLA. However, those who are considered a covered family member has been greatly expanded to not only include a spouse, son, daughter, or parent, but it now also includes siblings, parents-in-laws, grandparents, and grandkids, as well as individuals, this is a quote, individuals related to the employee or by blood or affinity whose close association to the employee shows to be the equivalent of those family relationships. So there appears to be a little bit of subjectivity to standard of who it now could cover. The benefits are for 12 weeks paid leave with a max benefit of 95% of the employee's regular pay at a cap of 60 times the state's minimum wage. This is mandatory for all employers to participate in, or they can opt out of it and purchase their own private insurance that would provide equivalent benefits. Next slide, please. Okay. This next slide highlights a very interesting trade secret case that was recently decided by Judge Muckhauser in the complex litigation docket in Hartford. And I guess I personally found it interesting because I actually tried a trade secret case before His Honor not too long ago, only just a few years ago. So it was interesting and good to see what findings he made in this case. As noted in the slide, the trial lasted for 109 days. And for those of you who aren't familiar with trials, that's a long time. And it was conducted remotely. So that makes it an interesting trial in of itself. And here the defendant employee was sued by his prior employer for misappropriating an alleged trade secret, which in this case was a type of poured concrete flooring. And as you can imagine, as with any trade secret case, it was extremely fact-based to determine whether the product at issue, which was a product called polycrete, and which was the product created by the defendant employee's former employer, whether or not it was similar to or was it derived from the new product that was developed to compete with it, which was called Procrete, quite similar. In fact, there was apparently a demonstration, the memorandum decision indicated there was a demonstration at a warehouse in West Hartford that His Honor witnessed to observe the mixing and the using and the drying of the product, which you can really say it really takes the idea of demonstrative evidence to a pretty high level, and actually something I could see Judge Muckhauser actually observing my experience with him. This case had a whole lot of interesting points to it, including finding a perjury of the defendant at one point for lying in court, as well as during his deposition. That's a whole other issue. What makes this case relevant to employers is that the court made a finding of no liability to the new employer for the defendant by noting that neither the employer, that is, the new employer, neither knew nor had reason to know that the defendant employee was using trade secret information. Now, given the procedural history of this case that I looked at, and it's quite long, I don't doubt that this matter will be appealed. But in the meantime, the memorandum decision itself, as it is, currently provides a pretty good fact-based finding for any employer who may be defending itself on a CUSA case on the basis of knowledge. In other words, I guess the takeaway from this is that if you don't know that your new employee that you just hired had misappropriated trade secret where they came to work for you, or you didn't have any reason to know, then you likely would not be found liable under CUSA. At least you wouldn't be under this court's ruling.
As opposed to the employee, however, the employee may be hoisted by their own wrongdoing, right, Calvin? So that
Absolutely, yeah.
Yeah, so it sounds like this is kind of like it validates But I guess for those of us who are fans of the old TV show Hogan's Heroes, what I call the Sergeant Schultz approach, which is I see nothing, I know nothing. And so ignorance is a defense to a Kutza claim if you're the employer. But it strikes me that once you find out that the employee is, your new employee is using your competitor's trade secrets, you probably better part company with them pretty fast.
Yeah, and as you imagine, most of these cases, usually the former employer has sues not only the employee that's left, but usually the new employer as well, usually because they think they have the deeper pockets. So whatever defenses you can have or any sort of fact-based findings that might be good for you would definitely be good for a defense anytime you have to defend that. Okay, next slide.
Right, so we've got a few minutes left, and that should bring us up to the 2 o'clock ending time for us. So just some other developments. Families First Coronavirus Response Act, which was signed by former President Trump about in March of last year, which provided for paid leave for COVID-related reasons, whether you were sick or had to quarantine or had to miss work because of childcare issues due to the COVID closing down the school or childcare. That law expired on December 31st of 2020, but the legislation that was signed a couple of weeks ago with the most recent round of stimulus extended at least parts of this statute to March 31st. So employers are no longer obligated to give the paid leave, but they can if they want to, and they can still get the credit. And it's also worth noting this extension doesn't give employees a new bucket of paid time if they've already used it. They don't get any more time. But if they haven't otherwise used it up, and actually we're seeing a lot of that. A lot of people didn't use the time during the first months of the pandemic because of the PPP loans limited the number of layoffs. But anyway, employees may now, without these buckets, may ask for it, and it's up to the employer as to whether they want to give it or not. It's just switching quickly to the National Labor Relations Board, union issues. This is an agency that's probably the most political of all the federal agencies because it governs labor unions, and that's so highly politicized. So within literally minutes of President Biden taking office, leaving the stage and getting to the White House, he called for the resignation of the board's general counsel, Peter Robb. That demand, and he said, if you don't resign by 5 o'clock, I'm going to fire you. General Counsel Robb yesterday said, nope, you got to fire me. So Biden fired him. So it breaks with about a 70-year tradition of the new administrations letting the incumbent general counsel work out the remainder of their term. And General Counsel Robb, who was associated with a lot of the more sort of pro-management measures taken by the board in the last 3.5 years, was, I think, largely disliked by organized labor. And so, nevertheless, Biden, I guess, wasn't going to wait and has gotten rid of Robb within, minutes of taking office, again, breaking with the 70-year tradition going back to the Truman administration. So this signals a swift end to pro-management era of the Trump administration. So we can expect a lot more union organizing, very sympathetic board. And so brace yourself if you are interested in labor unions or have one in place or are worried about having one. So again, as we're talking, I mean, stuff just keeps coming out today. And yesterday we had more executive orders. We've got a new chair of the National Labor Relations Board that was appointed just today, late this morning. Yesterday, President Biden signed about more than a dozen executive orders. And just in terms of what did these include? We've got there's some more topics about racial and LGBT equality. You might have seen on Monday the Trump administration released a report from their 1776 commission that was designed to essentially correct what it perceived as distortions about the role of slavery in the history of the United States. Biden is basically disbanding that commission as of yesterday. We've got Trump tried to limit the amount of diversity and inclusion training that federal agencies could do, and Biden rescinded that yesterday. We've got an order that it was yesterday that basically reinforces this Bostock decision that Calvin talked about, that essentially recognizes that Title VII protects people on the basis of their sexual identity or sexual preference. And so this is an executive order that tries to harmonize or bring that into the federal agencies, and the Trump administration had resisted that. So lots of activity, and we thank you for being with us for the last hour. And if you have any questions, by all means, please use the chat. Looks like we have one question. Let me see what we've got here. Actually, I think we'll just follow up in writing on that one, an email. It's about the paid family medical leave. And so we'll respond to that. But if you do have other questions, please let us know. Please reach out to us, and please stay tuned for the upcoming seminars that we're going to present, or webinars for the next several months, which sort of is our way of spreading out our annual updates. So I suspect we'll be working in recent developments as they occur, because they're just coming fast and furious in this very, very busy environment. So thank you for being with us this afternoon. And also, there is a link to the, I think provided in the chat section, to the slides that you've been reviewing, as well as CLE forms if you need them. So with that said, thank you again, and enjoy the rest of your afternoon.
Yeah, thanks for joining us.